Hello, everyone. I'm Catherine Fisk. I'm a law professor at the University of California at Irvine. More importantly, I'm a huge admirer of the work of so many people in this room, and it's really thrilling to get to see some of you in person. I was asked to talk about members-only unions, which I have written about a couple of times with a couple of different people, and so that's what I'm talking about. Members-only unions are an experiment worth trying. In fact, to put the thesis right up front of this talk, the single most important reform of labor law that I think the National Labor Relations Board could do right now that would make a huge difference for the future of workers and economic justice is to tweak their law a little bit, to bring it into line with what the original intention of the National Labor Relations Act was, to require employers to recognize and bargain with an organization that represents workers regardless of whether that organization has secured a vote of more than 50% of the workers in an appropriate bargaining unit, however that is defined. If the board were to do that, all kinds of really exciting things would happen. Think about Chattanooga, Tennessee. The UAW narrowly lost an election, as we all know, but then they didn't leave. Those workers who wanted a union got what they risked their jobs for. That was awesome for them. It was a win for the VW Corporation that wanted an organization to talk to about what their workers want, how to run the plant better. It was a win for everybody who's thinking about new ways that workers can act collectively. And it was a win even for the libertarian-inclined workers in Tennessee who'd been terrified into believing that if there were collective action by workers, the economy would collapse and life as we know it would end. The only people who were terrified by it were the anti-labor strategists, the Republican loudmouths, who had promised, because that's what they get paid to do, that if you defeated the union in an election, the union would pack up its marbles and go home. Guess what? The union didn't. The workers stay energized. I have no idea what's going on. I'm not on the inside track of that. But I think it's enormously significant for everybody that the UAW decided to experiment. It is an ideal strategy for the 24 states in the United States that have right-to-work legislation, and for any labor organization, whether it's a union or styles itself as a worker center or whatever else, who thinks that a significant number of their potential members are fundamentally libertarian. I've got teenage and 20-something kids, and although I'm a lefty socialist and my spouse is a lefty socialist, our kids actually are much more libertarian than we are. That's, I think, the reality. And my law students, all 20 years that I've been teaching, tend to be more libertarian than I am. What's appealing to them about, but they're not anti-collective, I will say. They do things like join fraternities or sororities that wind up being huge in their lives. They belong to churches or other kinds of religious groups. They belong, they join, they seek community, but what they're a little anxious about is the traditional model of unions that says that once a union has been selected by the majority, it governs everybody. And frankly, those Democrats who now recognize that some other party controls the majority, they're a little anxious about it too. Nothing like disagreeing with some aspects of your elected representative to make you a little more libertarian. The advantage of members-only bargaining is that it allows anybody who wants to join to be involved in the union. The union will negotiate with the involvement of workers an agreement governing its members, and then we'll see. We will see whether the collective agreement that's negotiated for and by the workers who choose to join is better than, the same as, not as good as what the employer's unilateral terms of employment would be. But I think that's a great experiment to convince those people who would like to have collective representation but are anxious about the majoritarian exclusivity principle that the board has, in my view, wrongly in the past regarded as the only possible avenue of unionism. It gives them a chance to see what it's like. I think this is particularly important in the 24 states that are right-to-work states, and of course for home care workers in the public sector who under Harris versus Quinn. The reason why is that the whole heart of right-to-work is that we should all be libertarians. That is, we should only be bound by the rules of the organizations that we choose to join, and that we should only have to pay for the services that we choose to have done for us. That's not the way that labor organizations traditionally have operated. But I think if what we're facing is a right-to-work world that's going to spread rather than shrink in the years to come, and regrettably, I think there is, unless there is a change in the Supreme Court, I think that members-only bargaining is perfect. Particularly, I think the board should do this in states where the union is prohibited by law from charging workers for the services that the union is legally required to provide under the duty of fair representation. I don't think any of us believes in a system where you get benefits without paying for the cost. You can't drive on the roads unless you pay your taxes. We all pay taxes whether or not we happen to like the people who were elected to make decisions about how to spend that money. It's astonishing to anybody outside the United States that we have a world in which unions are obligated to provide valuable legal services like grievance arbitration to people who have no legal obligation to pay for it. So what the board could easily do in 24 right-to-work states in the private sector is say, if you don't pay an agency fee, then the union has no obligation to represent you, at least in grievance arbitration. That would be a tiny little change, entirely consistent with law. The small examples we know of what happens, anecdotally, I am under the impression, and I think there are people in this room who may know more about it than I do, that is the rule in Nebraska, a right-to-work state. But for Nebraska teachers, I am told by somebody from Nebraska, the union does not have the obligation to process grievances for non-fee payers. What's the result? They can grieve their own contractual disputes. They can hire their own lawyers, if you could find one, to handle a grievance at the price that anybody can realistically afford to pay, which is not going to happen. What happens in Nebraska is they have very high membership in the union, even though it's a right-to-work state, because people realize the benefit that they get for their fees. The problem with right-to-work, in my view, is that people think they get services that their coworkers who are union members are required to pay for that benefit them. You know, which one of us would pay taxes to support what we hate about whatever it is our elected representatives do if we didn't have to? We'd support what we wanted, but not what we don't want. All that right-to-work should do is say, if you don't pay for services, you don't get services that are paid for by your coworkers. The final thing I want to say is, what's the difference between members-only unions and worker centers and all the other fabulous models that we've heard about today? The basic difference, I think, was summed up by Sarah Horowitz. The revolution will not be foundation funded. I love that line, and I'm going to steal it with attribution to her all over the place. Members-only unions, like unions, are dues funded. They recognize that you have to contribute to the organization that represents you. And I think it is important that workers understand that what we're doing when we are unionizing is committing ourselves, our time, our resources to benefit each of us as individuals and all of us collectively. And that's what the dues model does. Apart from the fact that it enables organizations to be sustainable and scalable and to fund real research that enables better campaigns, both contract campaigns, better organizing campaigns. The paying of dues requires people to think about, I'm obligated to this organization. It's my job to support it because I benefit from it, because my coworkers benefit from it. And so what I think members-only bargaining could do, if the board would read the law as I think it should be read, to require unions to employers to recognize unions, particularly in right-to-work states, even if they're not elected by the majority, is it's essentially a bridge between the worker center model, which is very small d democratic, is very much you join, you have to volunteer, this is something we do for all of us, and the unions as we have known them up to this point, which are fabulous, powerful, sophisticated, nationally scalable and sustainable organizations. So it's essential, members-only bargaining is a bridge from alt-labor, small but very vulnerable organizations, and the thing that unions have really done, which is to be powerful long-term organizations that are in a position to actually create working-class jobs for middle-class jobs for large numbers of people. I think members-only unionization is a way to get from the small to the truly large and transformative. Thank you.